Okay, you are now live, sir.
Thank you. Thank you, everyone, for your patience. Welcome to the City of Annapolis Board of Appeals special virtual meeting for December 10th, 2020. This meeting is being broadcast on the City of Annapolis YouTube channel. I'm Bob Gallagher, Chair of the Board. In accordance with city policy during the emergency, this virtual meeting allows the public to observe through a video link. Public also has the opportunity to submit written testimony through an online submittal process available on the City of Annapolis website. You'll find links to the YouTube channel and the city website for comments on tonight's agenda. So we'll begin with a roll call and we'll ask our recorder, Tammy Hook, to call the roll.
Mr. Gallagher?
Yes.
Mr. Zazali?
Here.
Dr. Chen?
Present.
Mr. Walsh? Mr. Burnett? Mr. Dews?
All right, it looks like we have a quorum.
Excuse me for a moment. Excuse me for a moment, Mr. Chair.
Yep.
Thomas Smith has joined us, and I don't see Thomas Smith on
He's part of planning and zoning.
Oh, okay.
Why don't you put him in the waiting room until he's got a case, if he has one.
Okay.
Good evening, Alderman Arnett.
Good evening, Mr. Chair. This is becoming a weekly habit.
I'm not sure if it's good or bad that you don't have anything better to do. So a couple more
I have
notes.
no life.
A couple more notes on the virtual format before we take up the agenda. So the people that you see on the screen, with the exception of the alderman, are members of the Board of Appeals. When a case is called, representatives of the parties to the case.
Jackie Rouse is not a member of the Board of Appeals.
On the screen. Well, she's an honorary member in a sense.
And her food's out here.
So also participating in the meeting are counsel of the Board of Appeals, Cheryl Woods, our recording secretary, Tammy Hook, one or more city employees like Mr. Smith. Also, Mark Hildebrand is managing the technical end of the meeting. We also may have other city employees, including Director Dr. Nash, Joelle Braithwaite, Assistant City Attorney and Counsel to the Department of Planning and Zoning, and could be other members of staff as well, in addition to Ms. Rouse. We ask everyone but members of the board to mute their audio. If anyone wishes to speak during the meeting, raise your hand and I will recognize you to speak. As I mentioned earlier, written public comments were accepted up through noon today on various cases. Comments submitted up until noon today are made part of the record and have been forwarded to the members of the board and the parties in advance of the meeting. Have the members of the board had a chance to review the agenda?
Yes.
Do we have any corrections or additions?
I don't think so.
May we have a motion to approve the agenda?
Motion to approve.
Second,
Second.
all in favor?
Aye.
All right, the agenda is approved. The first item on the agenda is approval of 4 sets of minutes that Tammy has so faithfully provided to us. October 21st, November 18th, November 30th, and December 1st. Do we have any corrections or additions to the minutes?
At least one of those you won't be able to vote on because I was not present, so you only have 2. I don't know.
I also was not present, Christian, for October 21.
So you'll have to table
So
that
it's
one.
you two who are missing for the 21st, so I'll carry that one over. May I have a motion for November 18th, November 30th, and December 1st?
Go ahead, Nadine.
So move.
Second,
Second.
all in favor?
Aye.
Thank you very much. You got that, Tammy? I know she does. She always gets everything.
Yes, I do. Thank you.
So we've got a very full agenda tonight, 5 cases. We will begin by deliberating on 2 variance applications and 1 special exception that we heard at our last meeting. Then we have a new variance and an appeal. The first case will be then variance 2020-06 relating to 603 Creek View. This one, I'll remind us, was a side yard setback for a garage on the opposite side of Creekview Avenue from the house. That's the setup for all the houses along that block there. The evidentiary record in the case is now closed. Have there been any additional comments on 2006?
Good evening, Mr. Chair. Kevin Scott, Senior Planner for Planning and Zoning. It's a side yard variance, also a front yard variance.
Yeah, okay.
And we have not received any additional public comments or additional evidence to be entered into the record.
Okay. So who would like to start? Dr. Chen, do you have any thoughts on this one?
Yes, Mr. Chair, I do believe that this application should be allowed. I think that where this property is located is in fact quite unique. And for that reason, I think the variance is reasonable.
For the reasons set forth in the staff report with attachments.
Yes.
And Mr. Zazali, where are you on this one?
I concur. It's a perfectly appropriate use of the variance request. It meets all the standards and guidelines and supports the planning department's recommendation.
Would someone like to make a motion?
I can. Mr. Chairman, I move to approve variance 2020-006 based on the evidence provided in the staff report, as well as testimony that we heard that was given, and also in view that there were no public comments.
All right, so second,
Second.
all in favor?
Aye.
Aye.
Aye. All right, so thank you to the applicants and Mr. Scott for your presentation and your patience. Happy to be able to accommodate you. The next case is variance 2020-008 relating to 14 Mary Avenue, side yard setback for a second-story addition. Again, the record is closed. Kevin, do we have any public comments on this one?
No public comments and no additional exhibits to be entered.
And my recollection is that we're going back a little bit and then adding a second floor. Pretty thorough analysis in the staff report that each of the conditions, each of the requirements have been met. Any thoughts from members of the board?
I'll start off on this one with the understanding that the interior space of the house is actually a little less than 20 feet wide, and bringing it up to modern standards. The request is minimal. I think it is the minimal relief necessary to achieve the modern domicile that is wanted and needed in the city of Annapolis. The property was laid out before the 1971 zoning laws or whatever they were. I think it has met all the standards. The evidence presented in the hearing and in the staff report support the application for the variance. And that is my motion.
All right, do I have a second?
Second.
All in favor?
Aye.
Aye.
All right, well, thank you again for the applicants and for Mr. Scott, your great work on this and your efficient use of the board's time. I hope it goes smoothly for you.
Thank you.
All right, so we'll move on to They carried over special exception application. I call this the dogs and cats case.
Number dog and cat case 2 that we have open together.
Right. This involves the interior expansion and renovation of the Annapolis Cat and Animal Hospital over there between Bay Ridge and Forest Drive. Nothing exterior, but because of the changes in the interior, they need to renew their special exception. Any public comments on this?
We have not received any additional public comments.
Good, that's great. All right, any, who would like to lead the discussion on this one?
Well, I think I was impressed with the follow through to update and expand the special exception. It's really only a matter of technical bureaucratic wonderfulness that we find ourselves here having to actually vote on expanding a few hundred feet of a vet facility, but they do meet all the requirements in all respects, as stated in the staff report and the testimony and evidence provided. And I motion to approve this special exception as submitted.
For a second?
A second.
All in favor?
Aye.
That makes it unanimous. Mr. Dowling, we thank you for your patience and wish you well with your expanded endeavor.
Thank you for your time.
To steal a quote from some famous general, go get them.
Thank you. We will.
All right, now we've got a new application, variance application 2020-02, relating to a property line adjustment between 38 and 40 Monroe Court. And the comforting thing about this one is that we've been through this once before, but the variance has expired. I guess we'll hear the reasons for that. So first of all, for anyone who would like to testify on this application, do we have anyone to testify on this application?
Yes.
Who would that be? Are they on the screen?
Tom Simmons and Tony Christoph and his witness, Bill Bauer. I think I see them on the screen.
Would the witnesses please raise your right hand and take say, I swear or affirm, subject to penalties of perjury, that the evidence I give tonight will be the truth to the best of my knowledge. Have we all done that? Okay. I'm not sure everyone's got mute turned off, but I think we heard everybody. All right, so as usual, your diligent Board of Appeals has read the file front to back, and those of us who were around in 2017 will also remember this case. So there's no need to belabor much. For each of you who will present tonight, let us know what you think is important that we might not get the proper flavor or emphasis reading the file. So we'll start with an introduction by the city. Who's that going to be?
That would be me.
All right,
Kevin
Kevin.
Scott, Senior Planner for Department of Planning and Zoning. It's VAR 2016-025. Variance application by John C. Taylor III, Nancy M. Wells, Sheila T. Alsop, and Berna P. Beans, owners of 40 Monroe Court, and by Joseph I. Nasaka Jr.
Let me interrupt you, Kevin. That number was the last time around. You've got a new number now, don't you? 2020-002?
Yes, thank you. VAR 2020-002. Honestly, I recycled my old staff report from the 2016 application. And
We'd like to see efficiency in city government.
Well, I made some edits to bring it up to current, but so to note, these are reductions to the minimum lot area and lot width to allow an administrative subdivision to proceed for the purpose of reconfiguring the common boundary line between the contiguous parcels between 38 Monroe and 40 Monroe. They're reapplying for the previous approved variance, VAR 2016-025, which was approved by this board on August 31st, 2017. And it subsequently expired after 2 extensions on August 31st, 2019. With this application, there are no substantive changes from the previous variance, which is why I recycled my staff report, except new survey work did change the quantification on the required variances slightly, but our staff recommendation stays the same. Essentially, they have a new surveyor, new survey work, so more accurate dimensions of the lots. They're basically moving 259 square feet from one lot, adding 259 square feet to the other lot. One lot gets 3 feet narrower at the front, the other one gets 3 feet narrower at the front, the other one gets 3 feet wider at the back, 3 feet narrower at the back. You know, so it's just zigzagging the lot line. They have an exhibit that shows a blow up of what's happening with the lot line adjustment. So basically that's it. We supported it before, you approved it before, we support it again and recommend that it should be approved again.
All right, who would like to speak for the applicant? There's someone who needs to unmute themselves.
Yeah, sorry, I demoted one of them by mistake, so he's back.
All
I
right,
think we're looking for Tony Kristoff or Anthony Kristoff.
Anthony is in as a panelist, and I'm asking him to unmute.
Mr. Christoph?
I'm here. Thank you, Mr. Chairman. Anthony F. Christoph. I'm the attorney for the owners of 40 Monroe Street, applicants for the variances before you this evening. And also with us is the attorney for 38, who will probably identify himself if he can hear me.
Yes, I can hear you, Tony. This is Tom Simmons. I'm counsel for the owners of 38 Monroe Court, Joseph Nisaka and Katie Weldon.
Okay,
Mr. Chairman, as Mr. Scott has pointed out, the applications before you are substantially the same as those granted by the board in 2017, specifically variances to the minimum lot area and lot widths for both lots. The case came before the board originally arising out of litigation that was filed regarding an adverse possession claim as a part of the settlement agreement. It was agreed that a administrative subdivision would be entered into by which there would be slight conveyances back and forth each to the other of small areas of each of the lots. Unfortunately, we were unable to, or the then surveyor for the properties was unable to get a subdivision application filed, notwithstanding 2 extensions by this board for 6 months. Then the COVID situation additionally delayed. The firm of CP Johnson and Associates was engaged to do additional survey work and prepare the new application. And we have with us this evening Bill Bauer, who is a licensed surveyor, has been recognized by this board as expert in that capacity. He's also a principal with the firm of CP Johnson Associates. If the board's agreeable, given time constraints, I would briefly proffer Mr. Bauer's testimony and then ask the board if it has any questions. If that's
yeah,
any.
why don't you do that?
All right. As Mr. Scott has pointed out, there are slight changes in the calculations as a result of the survey work done. Specifically, the existing area of 40 Monroe is now 5,435 square feet, 4,012 square feet. The width of 40 Monroe is 26 feet. The width of 38 Monroe is 29 feet. As a result, variances are for 40 Monroe, 224 square feet to the 5,400 square foot minimum and 22 feet to the 50-foot minimum lot width. For 38 Monroe, the variance to lot area sought is 1,129 square feet to allow a lot of 4,271 square feet and a variance of 23 feet to the 50-foot minimum lot width requirement.
Mr. Barrow would indicate that he is a professional land surveyor, has previously qualified as expert. He's familiar with the subject properties, familiar with the previous variances, familiar with the board's previous determination granting the variances, indicate that he has done or has done under his supervision the variance application and additional survey work resulting in the variances which I just indicated to you. I would note that the the minimum lot width variance sought is exactly the same as was previously granted, notwithstanding the slight change in the dimensions resulting from the survey work. The minimum lot area variance for 40 Monroe Court is actually 173 square feet less than that previously granted. The minimum lot area for 38 Monroe is 78 square feet greater. Mr. Barrow would also indicate that he's familiar with the variance standards. He agrees with the previous submittal relative to the application meeting the variance standards as was previously determined by this board in its decision. I would note for the record that the affidavits of posting, publication, and mailing have been submitted to planning and zoning, and also at this time move the exhibits which have been previously submitted as part of the record.
Not hearing any objection, we'll admit those exhibits for the record. Any questions from the board for Mr. Christoph or Mr. Scott?
Dr. Chen, you have any? I have one just as a matter of public curiosity. Is this fixing something that has existed since time immemorial, or is it resolving a dispute that's recently occurred? And I assume since both parties are represented by counsel, both parties are in agreement that this is the correct path forward here. And we're not going to see this in litigation later.
No, as a matter of fact, as I said, it arose from litigation. There was a claim of adverse possession filed in circuit court by the owners of lot 38. The conclusion was that in fact, the improvements in the use of the properties was pretty much as was pled in that proceeding. A settlement agreement was entered into, and the applications for variances necessary to effect an administrative subdivision are the reasons we're here before you tonight.
Okay.
Dr. Chen? So there are structures on these lots, are there?
And have been since the 1920s, Mr. Chairman.
And looking at the plat that was attached to the staff report, it has lot numbers, but not house numbers. So I can't tell which lots we're talking about.
202R is 40 Monroe Court. 203R is 38 Monroe.
So in lay terms here, somebody on 38 built something and somebody on 40 objected, or vice versa?
Again, over time, Mr. Zazali, apparently a fence was erected and it actually joins the rear of the two structures, but then proceeded up inside of, if that's the proper term, west of the actual lot line of 40 Monroe Court. And that area had been used by the owners of 38 Monroe for more than the 20-year period to establish adverse possession.
Got it.
Got it. Okay. I'm good.
Now we get the story. Got it.
All right. If there are no more questions, then, are any more questions? Under our virtual meeting procedure, we're required to hold the record open until our next meeting in order to provide an opportunity for anyone who's watching tonight to submit comments in response to what they've heard tonight. So we will not make a decision tonight, but at our next meeting, which I think is on, Jackie, is it the 16th or 17th?
It's the 16th.
16th, yep, 1/6.
Right. All right, so we'll make a decision on December 16th. And we thank counsel and your clients for their patience and brief presentation. And thank you, Kevin.
Thank you.
Thank you.
And we'll move on to our next. For those watching from home, anyone who has comments on this application, you need to get them in by noon on December 16th in order for the board to take them into account. So finally, tonight, we have an appeal. Appeal 2020-006 by Franklin Bernard, John Latazori, Fred Guckus, Gary Schwerzler. A decision by Dr. Nash concerning the approval of the residential neighborhood conservation site design plan review application.
I guess my video, is your video on?
My video is on, as is
I
my,
guess my video.
as is my audio.
We can see you, Maple and Terry.
Fantastic. Terry, I think, is trying to get his audio going.
Okay. We're here.
Okay.
Mr. Chairman,
Yes.
before we proceed, I need to disclose to the board that I did have a conversation with one of the appellants prior to this hearing. Nothing in the conversation is not included in the record as the board has been presented all of the documents, but I feel it's necessary for me to disclose this conversation.
Are you offering to recuse yourself?
I am.
Yeah. I think that's probably a good idea in light of the sensitivity of ex parte communications on an active case. I think that's the safest thing to do. Christian, do you want to weigh in on that question?
If Dr. Chen doesn't want to offer any information regarding the nature of the conversation, I would tend to agree.
Yeah, I think that's fine. I don't think that will slow the progress of the appeal. Let me tell you why. We can't decide it tonight. But what I was planning on doing in any case was I wanted to remind the appellants. Are you represented by counsel? Any of you?
No, we're not.
Okay. There has been a change in the law that affects the standard of review when it comes to cases on appeal. In the past, when a case like this came to us, the proceeding before the board would be like starting all over again. We would consider all the evidence that the department had in front of it. And if anyone had any new evidence, and we would take testimony from the public, consider what they had to say, and the board would make its own decision. We called that a de novo review because it was brand new. The law recently changed, and the changes apply to this case.
Oh, wow.
And the standard of review is now a review on the record before the Department of Planning and Zoning, before the director. And what that means is that decisions of the director, because of the expertise that resides in the department, are afforded substantial deference by the board in taking up these appeals. So there's something of a presumption of correctness. Now that deference is not without constraints or limits. So as appellants, your burden is to prove that the director's factual determinations are not supported by substantial evidence in the record in front of the director at the time she made the decision. And by that, we mean that the evidence that the director relied on was not convincing enough that a reasonable person could not reach the same conclusion. And of course, if you can demonstrate that the director's conclusions were wrong as a matter of law, that's also a ground for reversal. So under this new standard, we generally do not hear new evidence. Our decision is based on the evidence in the record. And of course, we welcome arguments of the parties as to how the director's decision does or does not meet the new standard. And by that, we ask you to focus on the criteria for granting approval in this case that are in the law. Take a look at those criteria and look at the record developed by planning and zoning and make the case to us that the facts in the record don't provide a sufficient basis for the conclusion that the director has reached, or that the conclusions she has reached are wrong as a matter of law. Is that clear? Am I understood?
Yes.
Okay. So I'm not sure to what extent you anticipated that, but assuming that you might need some more time to think that through, what I was going to do is see how much time you think you need, and then we'll schedule the arguments and our deliberations for a subsequent meeting. So is that agreeable to everyone?
Yes.
Okay. Mr. Braithwaite, is that good for you?
Mr. Chair, we are agreeable. I believe that there was a discussion previously amongst the parties about this day 12/10 being a day that people anticipated moving forward. So I'll defer to everyone else, but it's a good day for the city is good enough to defer to the board.
Okay. So let me just ask the appellants then. Would you like give me an idea of how long you think you'd like to prepare for that, and then we'll fit you into the schedule. If you want to get back to us, if you want to caucus among yourselves and get back to Ms. Rouse, then she'll get it on the schedule.
That would be great. I appreciate that time to do that.
Terrific.
Mr. Chair, can I ask the appellants in that process, as we have been going through this submission of the application, revisions, approvals, appeals, that there is some degree of urgency in setting such a date, as we have continued this process for quite some time in a very bewildering manner to me.
Well, I'm certainly going to consider requests from all of you. If you don't agree on a date, tell me what your proposal is and why you think it's better, and we'll decide.
Okay. I just want to make sure we understand and what I'm presenting to you is exactly what you need to hear, and I'm not going off on a tangent on this. So I want to review what we've put together and make sure it checks the boxes that you just told us.
Okay.
So we'll try to do it as quickly as we can, but we just need a little bit of time to look at this and to do this. And I won't try to delay it any more than we absolutely have to.
Good. Well,
So,
Jackie, do you have something to say?
Bob, I have a question. So if we don't continue it to a specific, will we then have to re-advertise?
That's a good point. So let's continue it to a meeting that we know is on the calendar. And then if for some reason that doesn't work out, we'll continue it again. Should we just call it January 5th?
January 5th is the first meeting in January. That would probably, if that's acceptable to the appellants, we have a second meeting in January also.
Let's call it January 5th. And then each of the parties can let me know if that's a problem and why we should change it and what we should change it to.
The advantage of that is that then we do not need to re-advertise, re-notify, and repost.
Yeah, that's more efficient. I appreciate the suggestion.
Bob, would it make sense for me to present my staff report tonight? Or you'd rather do it all at one time?
Well, we can do that. It might be an advantage to the appellants to hear what the city has to say. Would you like to do that?
Are you going to have the other members read in on this one or watch in?
We can do that.
Because it's just the two of us. We don't have a quorum.
Right. So we can't do that. We can't hear evidence tonight
Oh, okay.
because we don't have a quorum, Sally. Sorry.
Right.
Thanks, Chris.
But we can still request, Bob, but we still can request that the other members who will be attending on January 5th read into what was discussed tonight.
Yeah, it's 15.
Such that it exists. Yeah.
It's.
Yeah.
Okay. Well, I think we're good then. So we will recess the hearing on this appeal, 2020-02, I think, until January 5th, unless a different date is set.
2020-006, Bob.
006. Yeah, I don't have a head for numbers. All right. That sounds good to me. Anyone have anything else they think we need to know about before we entertain a motion to adjourn? Well, sounds like people want to get out of here. May I have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
All right. Thank you all very much for
No new
your-
business, I assume, right? Goodbye. Yeah. You didn't ask